In Ottawa, the House of Commons is about to consider the new revised version of the Charter of Rights. In the flurry of anguish and self-congratulation on women and on Native people, disabled people have been almost forgotten. My next guest is David Lepofsky, a lawyer who is himself blind and who has specialized in law affecting the disabled. He's on the line now. Good morning, Mr. Lepofsky.
Good morning.
Could you spell out exactly what the Charter of Rights will give disabled Canadians?
Well, up until about a week ago, it was going to give us a lot. Unfortunately, with the latest draft that they're offering us, it's going to give us virtually nothing. Section 15 of the Charter, the Equality Rights section, was supposed to guarantee equality status for all minorities in Canada. It provided that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination on such bases as race, national or ethnic origin, color, religion, age, sex, or, and particularly of concern to us, physical or mental disability. You see, what we're seeking is not some special status for disabled people, but to be recognized as a minority who is entitled to equal rights like all other minorities. Originally, the Charter did not include the words physical or mental disability, and we fought very hard. I, on behalf of the Canadian National Institute for the Blind, testified before the Constitution Committee seeking the inclusion of the disabled, and many other disabled groups and non-disabled groups pushed, resulting in what we felt to be a major victory last spring. The government agreed to include the disabled as an equal rights minority. Unfortunately, we've had a colossal setback in the past few days, one which people aren't really all too aware of, and one which is extremely distressing. You see, the Equal Rights section, Section 15, is going to be subject to what we've all been hearing called as the legislative override.
Mm-hmm.
What that basically means is rather disconcerting. It means that Section 15 guarantees our inalienable right to equality, except when the government takes it away. It makes the Charter into an umbrella that protects us from rain, but which is taken away once the rain starts falling.
When override was the core of the argument about women's rights, there was a position that one could take that said the override could be a good thing. People could put in discriminatory clauses that would give extra rights to the women on behalf of women. That was that argument. Is there any similar argument about the disabled?
That argument is totally and utterly false. Section 15 sub 2 allows laws to be passed which are discriminatory in favor of a minority when their objective or where their aim is the amelioration of the conditions of a disadvantaged group. So that, for example, a law could be passed providing some technical aids or braille typewriters or whatever for disabled people without it being accused of being discriminatory, as long as its aim was to give an extra helping hand to a disadvantaged minority. So Section 15 sub 2 automatically protects that sort of thing. The override is absolutely unnecessary in that connection.
I know you're the last person in the world of whom I ought to ask this question, but why would they take that phrase out? Why have you lost what you appeared to have gained?
Well, the reason that the override, there's a nice little quiet move going on that people have not understood and the media has not really covered. You see, Trudeau originally offered to entrench a charter to have inalienable rights in the Constitution.
Right.
Okay? And that was what he was offering, and it would bind the federal government in federal power areas and provincial government in provincial power areas. So what happened? The provinces said, no, we don't want it. And they held out and they fought for a year and they went to the Supreme Court of Canada and they bargained and they called each other's names and all this sort of thing. So the provinces finally entered into a settlement a couple of weeks ago. What did it say? It said that the provinces would get the charter, it would bind the provinces, but that they could override it when they used one of these override clauses. And we were told that the provinces would probably not use it because, after all, it would be politically embarrassing, and they even used the term political suicide for them to use it. Well, there's two very interesting things going on. Firstly, I don't believe that the provinces would fight for a year to get an override section put in the charter unless they really wanted to have it. I can't believe they go through all that effort for something they don't really want to use. I also think that it's rather surprising. We're told that it was thrown in to protect provincial rights, and we can understand that. I may agree with it, may disagree with it, but we can understand that. Interestingly, the override section of the charter adds into it an override in the hands of the federal government. What that means is the federal government can make laws which violate the charter, and in the case of Section 15, which discriminate discriminate against minorities, whether religious, racial, sex, or handicap or other minorities. And they can use an override to basically make the charter not apply.
So this is the unchangeable law unless we decide to change it.
Not only that, but why did, I mean, that's bad enough. That's basically making the charter substantially meaningless. I mean, what are inalienable rights when they're not inalienable? But more importantly, the federal government claims that the override is there to protect the provinces. But they've slipped in this federal override which protects the federal government. I've talked to Justice Ministry officials, and they've given me such answers as, we won't use it, or it would be political suicide to use it.
Yeah, there's that whole question of if they don't want to use it, why have they got it there? Could you give me, I guess it's a hypothetical question, but it's real to you, something specific that could happen with the override that would be of damage to the disabled?
There are several laws on the books across Canada today which discriminate against the disabled. There is a crime in the Federal Criminal Code for having sexual relations with a feeble-minded person. Now, I don't care whether people have been charged under that lately or not. It's on the books. The Ontario marriage legislation provides that you cannot get a marriage license if you're mentally defective. There are various provincial and, under the Canada Labour Code, federal laws which permit employers under certain circumstances, sometimes vaguely defined, sometimes specifically defined, permit employers to pay handicapped people less than minimum wage.
There is such a law?
Yeah, it's not blanket across the board. You have to get a government license, but sometimes those licenses can be handed out in a rather discretionary manner. This is discrimination which is clearly intended. It may be intended to be beneficial or whatever, albeit with a paternalistic attitude underlying it, but nonetheless, it is discriminatory. And, when we're told that it would be political suicide to add an override to a statute like that, that conjures up the following hypothetical. Could you imagine one of the provincial premiers being turfed out of office during an election campaign because they enacted a law that discriminated against the disabled? Can you see people making their votes in an election determined, at least, based on how a particular innocuous statute affecting disabled rights was phrased?
I'm still left with the question that troubles me right from the beginning. Particularly, this is 1981. It's the year of the disabled. And we have here some forces at work which are arguing that the law or the legal situation you're describing, where it's okay to discriminate against the handicapped, people are supporting that.
It's pretty distressing that the Year of the Handicapped, whose theme is equality, was originally the year in which we thought we got our most substantial breakthrough, our inclusion in the Charter, like all other minorities. And I have to emphasize, we're not talking about special rights. We want to be treated as an equal rights minority, like all other minorities. Unfortunately, what we thought was our major breakthrough would be the lasting monument to the Year of the Disabled, has in fact been subjected to this legislative override, and as a result, will make it quite farcical.
Yeah, Mr. Lepofsky, I got a kind of final question for you. We have seen active demonstrations and effective demonstrations on behalf of similar situations, if I can say that, with women and with Native rights. Those things got into the Constitution largely because of demonstrations not only from within those communities but from the population at large. Are we going to see the same thing with the disabled?
The purpose of an equal protection section is to protect the rights of a minority who cannot get the ear of the public and therefore can't get a fair shake out of the political process. We're going to try our best. I've heard some vague rumors about London, England, if Ottawa doesn't listen. I don't know about that myself. We're going to do our best. We would urge people to contact their MPs and say that they think that equal rights minority section, Section 15, should be not subject to any provincial override or, more importantly, any federal override. You should know, by the way, that one of the most important decisions under the equal rights section in the U.S. Supreme Court in the entire American experience with equal rights was the decision to desegregate schools, saying that you can't have separate schools for blacks or for whites. Had there been a legislative override in the United States in 1954, when that case was decided, the chances are, and the likelihood is, that the schools would never have been desegregated in the United States.
Nice point.
So if a charter is going to mean anything when it's protecting the minorities who can't get the ear of the majority, can't get the ear of the political process, of the political system, then it's got to protect rights from precisely actions like a legislative override.
Thank you very much.
Thank you.
I've been speaking this morning with David Lepofsky, a lawyer specializing in the law of the disabled. He's at the Harvard Law School this year studying civil liberties and constitutional law.